Konrad-Adenauer-Stiftung, for those of you who are not familiar with it, is one of the 6 German political foundations engaging in support of democracy and the rule of law through our 100 or over 100 offices worldwide. On all continents, Konrad-Adenauer-Stiftung has regional rule of law programs, and it is also my pleasure to introduce to you Dr. Franziska Rinkel, the coordinator of the programs at headquarter level, and also Dr. Marie-Christine Fuchs, the director of the Rule of Law program in Latin America, who also joined us for this international conference. In 2018, the Rule of Law programs put the quest for judicial independence as their leitmotif for the year, and CAS also signed a memorandum of understanding with Diego Garcia-Sayan in his capacity as the UN Special Rapporteur for the independence of judges and lawyers. Those 5 regional rule of law programs organize discussions in their regions addressing the importance of integrity and judicial independence as a prerequisite to a functioning justice system. They also drew attention to the undue influence on the judiciary and how to protect judges against it. These workshops at the same time were also unique occasions to take stock of the shortcomings and also challenges which exist for judges and lawyers. Now this Greentree retreat aims to take the topic a little bit further and seeks also to reflect on how the UN basic principles of the independence of the judiciary could be developed further in order to establish and to strengthen a coherent protection mechanism. And particularly our session on Monday morning will dedicate time to discuss a little bit the way ahead, and will allow us also to strategize on how to generate support amongst UN member states in order to make the UN principles fit for purpose. Ladies and gentlemen, when we are addressing the threats to the independence of the judicial sector these days, we also do this in defense of liberal democracies per se. The scope of the problem goes beyond the legal sector and has also serious repercussions for the state of democracy worldwide, and particularly for the trust of citizens into the political system. Separation of powers implied for decades that checks and balances in the system exist, and that particularly the executive is held accountable. These days, the perspective shifts towards defending the independence of the judicial sector, defending the objectivity of the media sector, and also to assure the respect for the Constitution by legislators. Today, restrictions to judicial independence are not only limited to political directions on judicial decision-making, bribery, corruption, limited capacities, and a lack of economic security for judges. Even where judicial autonomy does exist, it does not automatically imply asserting independence by the respective judges. The limitations that we are seeing are often of an internal and/or external character. Threats have become sophisticated and bear a direct impact on the political landscape of the country. Partisan political appointment of judges, especially on the highest echelons, have repercussions on the selection and quality of political leadership. They bring ramifications on national as well as on international level. In contexts with flawed electoral processes, for example, quite often the judicial avenue is the only way for the defeated to challenge proclaimed election results. And it's just the recent case in the Democratic Republic of the Congo. The Constitutional Court, composed of hand-selected judges by the incumbent, approved electoral results presented by an equally biased electoral commission. Irrespective of the fact that election observer reports showed strong evidence that according to the data collected, the winner had been somebody else, the incumbent has been able to select his successor. And this happened in complicity with the Constitutional Court and in revocation of the political will of the people. So it needs very strong and brave personalities with a high level of integrity to advocate for independence. And I'm very pleased to have amongst us participants who, in the face of tremendous political pressure, did not deviate an inch from their ethical convictions. Ladies and gentlemen, about 15 years ago, our discussions might have focused much more on the dichotomy of judicial accountability versus autonomy. And particularly in established liberal democracies, we would have cautioned about too much judicial autonomy and the increased transfer of controversial and unpopular political decision-making from the executive to the courts, especially to the constitutional courts. Today, when the liberal democratic order and with it the independence of the judicial sector come under threat, we need to seek again ways and means that allow us to safeguard achievements, to equip the judiciary with the right mechanism of defense against these contemporary challenges. And we have to restore confidence of citizens into the judiciary as into the political and democratic system as such. And on this occasion, I would like to thank all of you for having accepted our invitation to come to Greentree, for having shown interest in support of the cause of the UN Special Rapporteur Diego Garcia-Sayan, and for accompanying his endeavor of a review of the UN basic principles. But let me also, last but not least, also thank my colleague Monica Castillejos for her excellent support in putting together this conference and to reach out to you to work day and night incessantly on the content as well as on the logistical side. So I think she really deserves a round of applause. Thank you.